I think you need to go in and have a realistic conversation. And when clients reach out to me, I tell them, look, if they're telling you that, they're just
not being real.
They're just not being real. They're lying to you. Nobody can make that kind of promise to you up front in the beginning of a case.
What if they make the promise on a billboard on 95? Is that okay?
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hey everybody, welcome to The Defense Never Rests. I'm so excited about today's episode. My name is Patricia Baxter and I'm your host. Today we are getting in the heads of plaintiffs' counsel. We've all been in those mediations or settlement conferences or case management conference where a plaintiff says something or does something and we're like, are they being an advocate? I can't believe they just said that. They can't really mean it. So today we're going to kind of get into their heads and get into the secrets behind the plaintiff's practice. Co-hosting with me today is Oliver Brooks. Hey, Oliver.
Hello.
And we have two of our favorite plaintiffs' lawyers. First, to my right, she is at the forefront of the vaping epidemic. When I had questions about what was going on in the vaping epidemic, my stepson vapes, and I had issues with it and questions about it. She's the first person I thought of, the first person I reached out to. And I'm so happy that she's here. Tracy Finken, welcome. How are you?
Thank you, Trish, for having me.
I'm glad you're
Appreciate it.
here.
Thanks for having me.
And then for Dan Sherry, who is our next guest, I'm going to let Oliver introduce him because he's probably going to be interesting.
Sure, and for those only listening, we have Dan Sherry Jr. Of Eisenberg Rothweiler. I met Dan opposing him on a rather significant post-collision fuel-fed fire case. Okay. We had 1.5 million depositions concerning first responders all the way down to the cousin of the mayor of the township where the accident happened. And we got to know each other very well, and I grew to very much respect him and his firm. He is a character, and that's why we've brought him on here.
Thank you, Oliver, for that suspiciously terse introduction. Before we slide off that, one of the reasons why we had so many depositions is that Oliver was quite successful in having the case moved from Philadelphia County to, I forget the name of the county, and that's probably not accidental. And as a result, the case, I think, took on much more of a defense. Realistic, perhaps better term of art, perception in light of the new jury panel that we would be having. Anyhow, I digress, but thank you for having me on.
Well, thanks, guys. We're going to dive right into it. One of the things that we're seeing lately, or maybe it's not been lately, but what we've noticed lately is an increase in demands, these crazy high demands. So much so that, when we sit down and talk to our adjusters and clients, one of the things they tell us is that it's almost impossible to settle a case in many venues because the demand is so high. The demand is forcing us to try cases, and that's what I want to talk to you about. How do you formulate a demand? We get these crazy numbers. We're wondering, where the hell are you guys getting them from? So if you guys could talk about what's in your mind when you get a case in and you have all the information you need before you put it forth a number, what goes into that process?
Do you want me to start?
Please.
There's a couple things, first of all, that come into play. Obviously, the extent of the damages. If it's a catastrophic injury case, that's going to be a different story than if it's a smaller damage case. Venue definitely comes into play. And to some extent, defense counsel comes into play, believe it or not. And of course, we have to sit down and have a realistic conversation with clients to see, where they are with this and being candid and transparent from the beginning in terms of demands. But with that being said, I think that some plaintiffs' counsel are probably very high, and some tend to give more realistic demands when they're going into it. And it really depends on if it's somebody you know well or not, and if you've been up against them before.
I certainly agree with all of that. A couple of other things, just when we think about demands, obviously there are initial demands that may come in right after the suit is initiated. In Philadelphia County, there's the case management conference where you are required to put a demand as opposed to merely stating you are suing in excess of $50,000. I think, however, since you used the term of art, crazy numbers, just I could slightly adjust that in terms of it.
You don't like my
Right.
terms?
No, I don't mind it at all. I don't. To use a comparison, though, sometimes if one is reading an answer to a complaint, a new matter that is raised, I'm sure everyone in this room has seen new matter that has been pled, affirmative defenses for those not in Pennsylvania, that you think to yourself, how in God's name are they pleading this? Like,
We don't do that.
for
We
example-
never do that.
Precisely,
Never.
but I understood. But I mean, but with an injured baby, for example, you sometimes might see an assumption of risk defense just being put out there in terms of that. It's a little bit of an extreme example, but part and parcel of formulating a demand is also a concern that if I do not set this demand at a certain level, am I boxing myself in where I may have a problem down the line? So yes, in addition to venue and the nature of the injuries, that nebulous concept of pain and suffering one must think about, and also if punitive damages are there. What is the maximum that I can put out there just so down the line I don't have an opponent being able to throw that flag of you didn't never ever set our expectations that it could ever be this. Again, that starts to change a little bit as the case progresses through discovery and you start to get to that mediation point that you brought up in your introduction today. But that is a concern, that if I just put down the boardables, which I understand people will look at and say, okay, here's a realistic life care plan, here's what we're looking at if we structure it out, et cetera, et cetera, et cetera. Well, the quip to that is that's just the money to take care of my clients. That's not going to my clients. Where's the pain and suffering associated with this? Where's the punitive reflected in this demand? So as a result, you may see numbers that don't jive if you're looking at it from a more arithmetic standpoint.
I mean, I've seen demands that are 100 times the liens. And, I'm like, and back in the 80s and 90s, adjusters would take the lien and multiply it by 3, and there's your settlement number or demand. I know that's so not the formula anymore. But is there a formula? Is it X plus Y plus Z equals a demand? Or is it gut? Is it experience? Is it jury research? What goes into it?
I think it's a combination of all of those things. And it also, what I was saying about relationships, if you have a relationship with defense counsel and you know each other and you're both straight shooters, you're more apt to put a demand out there that's really close to what your client will be willing to walk home with. But if it's a defense counsel that fights every single battle and you know that you're not giving yourself any wiggle room, you have to go high and be able to adjust down so that it can remain fluid as you're going throughout the process. I think it depends on the attitude of defense counsel as much as anything.
I very much appreciate my opponents who have a number, and that's pretty much what they want. That it's not, I want $100 million on this case when really I'm after $1 million. I would rather you say it's $1 million. What are you going to do? Or maybe you say it's 1.2 million. You're closer, but when I hear 100 million. You've made almost every decision for me at that point. I can't really deal with you. The way I've described it to non-lawyers is like if I decided I wanted to sell my 2018 Toyota Tacoma, it's an ordinary pickup truck, right? And you said you wanted to buy it from me. How much do you want from it? I said, $145,000. You would say, I don't need to deal with this guy.
I'm out of here.
Yeah. Now, if I said I'd take 30 for it, it's only got 15,000 miles on it. You would go, I don't know. I think that's a little high, but we're in the same ballpark. But when we have these 100 times the boardables damages, we can't really wheel and deal. And Dan has told me a war story about, I think it was another plaintiff in a larger case with a life care plan that was to build a hospital.
It was in excess of $300 million. Now, to that end, since we're now talking about relationships with defense counsels and having the ability to have that dialogue, which is very important, there is something though to be said of not setting demands such that you are infuriating whatever trial judge you are ultimately going to end up in front of. Yeah. As Oliver just stated quite accurately, you are making a decision if you put numbers out there that makes the case unresolvable. So, speaking from my own practice, we don't do that. But, I mean, this idea that we will look at a lien and we will thereafter look at what the lien might be and then project that outwards in terms of some type of rigid formula, that I can tell you is not only not followed in my office and not my learned colleague's office, but I don't know anybody else who would formulate it that way. It's just too elastic, the concept of pain and suffering and what those injuries might become, speaking here in non-death cases, as those cases progress through discovery. Certainly with the vaping cases, as I know you're involved in, it's difficult to project in terms of what that person may end up being as we close in on trial, and you want to give yourself the ability to maneuver. But the belief that you should be able to talk and converse candidly with your opponent if you have that relationship, obviously that's there, and those tend to be not only the attorneys that you look forward to seeing, but also the attorneys that thereafter become very successful neutrals for now the overwhelming majority of cases that end up in some type of alternative dispute resolution.
Yeah, and I think the relationships are key too. I mean, it's if you know somebody, if you know your plaintiff, and I take the opposite view. If I know my plaintiff's counsel, and I can have a real conversation, it gets the case done a lot easier. And you guys don't do this. I know you guys don't have these crazy inflated demands, but the ones that do, there's no talking to them. So you have to march forward. You have to talk to your client about going to trial because there's no other choice. They're not going to overpay. So.
Yeah, it's a two-way street, though, keep in mind, because we've had cases where I've had a very reasonable demand, realistic, a walk, demand, and then had defense counsel come up and give me, an offer that would require me to compromise the lien down to zero and take no fee from the case for the client to even have anything in their pocket, going forward. So it's definitely a two-way street. We see it on both sides of the aisle.
That's true. And I know that you guys don't do this, but we see this a lot where it's a week out of mediation and all of a sudden the demand rises. It's problematic and you guys know this, it's problematic from the defense side because we've roundtabled it with our client. Our client has talked to their supervisor who's gotten authority, and then we have to walk in and be like, oh, the demand isn't 2, it's 5. And you spend the good majority of your day trying to either convince them to go back to their original demand because we've already vetted that demand, or getting them down. And I know you guys don't do that, but I know you've probably run into it. Any secrets to that? Why is that happening? Is there any benefit from the plaintiff side to making that increased demand so late? Why not just give us that kind of demand in the beginning?
I appreciate the issues that you all would have with that because obviously it makes it really hard for you to be transparent with your clients and manage expectations on your end of the table too. I can think of one time in my career where that has happened and it was client driven.
Yeah.
It was 100% client driven. And sometimes, you can't, the client's driving the bus at the end of the day with your case, and you have to do what they want to do.
When that happens, I'll be honest with you, I smell weakness. It makes me think that plaintiff's counsel doesn't know his or her case as well as he or she thought she did during the course of discovery and litigation, and then at the last minute they go, oh, there's a lot more to this than we thought, or it means that they didn't control their client adequately, and that resolution is going to be really tough. But I do perceive it as a not a position of strength. As there's one firm in South Jersey that drives me up the wall that
we're not mentioning any names
that does it all the time. You'll get to a mediation, they're like, we said we wanted $200,000, we want $1.5 million now, and I'm like, well, maybe we should just try it,
Right.
To that end, to do something like that on the eve of a mediation is bizarre. I mean, let's take the hypothetical that immediately prior to the mediation, summary judgment was denied, which again doesn't really, at least in my own mind, move the ball very much. I mean, motions for summary judgment, presuming you put the case together, are supposed to be denied. I mean, no genuine issue of material fact is a fairly rare thing, provided it's not a nuisance lawsuit. But even let's assume that you get an order turning over something that is very, very damaging to the defense. You still would not expect the defense to say, okay, now you got it, now I'm going to show weakness by just, throwing money at you. If you think on the eve of mediation something revelatory has occurred, probably the professional thing to do is cancel the mediation rather than show up to the mediation with a massively inflated number. It's getting back to what I said earlier. Ultimately, you're going to be in front of a trial judge, and that trial judge is going to want to know what were the steps that you took to resolve this, since you are now appearing on my docket. Okay, and if somebody on the defense side is able to tell the court, look, we went to the mediation in good faith. We picked a mediator. On
Or
the eve
plaintiff's
of
counsel picked the mediator.
Or yes, we might get into that in terms of what is better optics in terms of who picks the mediator. But we did all of that, and then immediately on the eve of the mediation, the demand was increased by a factor of, I think your hypothetical, 250%. I mean, what is a trial judge to do with that? Hopefully be neutral, but understandably viewing the party that did that through a little bit of a skewed gaze, and understandably so. Well, how do you respond to the question then? How do you consider that negotiating in good faith? Okay, they're bringing people in, they're flying people in. You formulated a demand number with your mediation memo or whatever you submitted, and then all of a sudden we're going to spring it on you X. Now there's also a converse to that. You show up for a quadriplegia case or a third-degree burn case.
I know where this is going.
Right, and the initial offer is
$5,000, right.
or $100,000.
Right.
Okay. Now again, most people with a modicum of sophistication would say, okay, we're starting the process of playing ping pong, batting it back and forth. But if it's a defense pick for a mediator that maybe the plaintiffs aren't happy with, what's to stop them from leaving the mediation? And then when the trial judge goes, okay, where we are with the settlement negotiation, well, they offered $100,000. In a quadriplegia case, you offered $100,000. Like, well, Your Honor, and then you get a flurry of explanations. But it again puts you in a bad light in front of somebody who might make very consequential decisions, as opposed to a mediator, which is, can we see if we can get this case resolved informally?
No, it's good stuff. Our next topic that we wanted to talk to you guys about was what's in your mind when you get a case that has a weak liability defense. As Oliver would say, plaintiff's case sucks, but you have really good damages, right? What do you do with that, and do you handle those kind of cases differently than you would when you have a really great liability case?
I think first and foremost in those types of cases, because they do have value when you have a case that has really great damages and liability might be, iffy, so to speak. I would hope if there's no liability whatsoever, it's not necessarily a case we would handle. But if liability's iffy and they have great damages, we generally walk into it and really try to manage client expectations from the beginning. And I think that's when we, from the plaintiff side, need to really sit down and have a really candid conversation with the client that, look, this case probably should not go to trial. We will do what we can to try to get it resolved, but you really have to manage them from day one so they know going into it that the liability in the case is really going to be difficult to prove.
Certainly. And then even if, say, the substantive liability is perhaps better from a plaintiff's perspective, there might be wonderful legal defenses. Pennsylvania, for example, is problematic from a plaintiff's perspective when it comes to the topics of release and assumption of the risk and waiver. So, that might be a discussion that you have, that, look, we think that there may very well be a heavy deviation from a reasonable standard of care. However, here's what you signed beforehand, and you just need to be aware of that. Yes, damages does factor into the calculation, but there's also something to be said for liability driving damages. Even if you don't have punitive damages in a case, if the liability is patent, you can get a jury get very, very upset, and that will boost the damages. I'm not sure if the converse is true, even in pro-plaintiff venues, if I could put air quotes around that. The defense bar has become much better at defeating just the pure appeal to sympathy. So, if we're still within the statute of limitations and the liability stinks, for lack of a better word, find another defendant, find another way around it, but always, always, always be managing the client's expectation. And again, using the issue of waiver, that can be hard. That never crossed my mind when I executed this particular document. And they had no supervision. How could you possibly say that? That requires that type of ongoing dialogue with the client so that they're aware that this isn't an adjudication on the facts. It's a pure legal construct that we have to overcome, and it can be difficult.
And sort of an add-on to Tricia's question is, what do you do if you're 2 years into the case and the case before you is not the case that you signed up? Maybe your client didn't share all the details with you. Maybe they willfully withheld something. Maybe they didn't understand the significance of something. Or maybe we just did a really good job. You know?
I'll take that one. We
happens.
just did a really
You
good
know?
job. Right?
What do you do with that? And this office has crossed that path, I think, at least twice this year, where it looked really bad from the outset, and a year later, we're like, maybe we should try this one. Maybe this is one to do, you know? Luckily, in both cases, plaintiff's counsel was extremely realistic and just said, maybe we should really start talking about something a little bit above nuisance value for this. What do you guys do with that?
Listen, we've all been there, I think, where that has happened, and sometimes it's for circumstances that are out of our control. I do a lot of mass tort work, which pharmaceutical liability, you're reliant on doctors' testimony, and there's learned intermediary issues there. And if the doctor goes south and just hates lawyers, which sometimes they do, you know, they're not going to give you the testimony you need to get past a summary judgment motion. It happens, you know, and there's not a lot that you can do about it if you can't get, you know, that kind of good testimony to go forward. I still go back, and this is something I was lucky because I learned early on. It's about being transparent and managing client expectations from day one, and having an ongoing communication with them throughout the process. Because I know that there are plaintiffs' lawyers, and I won't mention any names, none here, but that go into clients and they say, look, sign up with me, I'm going to get you, you know, $1 bazillion for your case. And they do it because there's a lot of competition out there with plaintiffs' lawyers and getting clients retained. And it's just unrealistic. You're setting the client up with bad expectations from the beginning, and it's going to be really hard to manage those clients down the line. So I think you need to go in and have a realistic conversation. And when clients reach out to me, I tell them, look, if they're telling you that, they're just
Not being real.
They're just not being real. They're lying to you. Nobody can make that kind of promise to you up front in the beginning of a case.
What if they make the promise on a billboard on 95? Is that okay?
Well,
I don't think Dan
I'm
or
not on a
Tracy are on
billboard,
any
thank
billboards in the city.
I don't think so
The,
either.
the amount of, again,
Yeah.
were my face on a billboard, I think that there'd be a considerable uptick in automotive crashes.
I don't know what that means.
Pure distractions.
In a good way
Just
or a
means-
bad way?
means that I am not photogenic. That's what I'm saying. Yes, obviously you need to manage, and also you need to have that open dialogue, as stated, with your clients as the case progresses. However, to that question again, well, what if there's a factual development and you don't adjust? I would implore the defense bar to understand that just like you will not start throwing money at us just because you were ordered to turn over a document because you do not want to show abject weakness with that type of development, by the same token, assuming you really think you did a number on our client in a deposition, or you think that a doctor that supported proximate causation has collapsed, do not immediately expect some type of immediate recalibration in terms of the demand, because again, nobody doing litigation will be revealing that level of weakness immediately. That's just, there's nothing advantageous to the client for doing that. Yes, manage expectations, but it's still zealous representation. So yeah, I mean, cases develop with pros and cons. I have not had any case that has progressed all the way through trial where facts that were unexpected did not manifest themselves, pro and con. And it's the same thing with experts. I mean, some of the better experts, speaking now in the products liability field, they have a national presence. And as a result, they're playing in a lot of different ballparks, and there might be disadvantageous orders that come down that, again, change the complex of a case. We in Pennsylvania, at least in state court, don't follow. Is it Dalbert, Mr. Brooks? Dalbert? How do you pronounce it? I don't need to know because
always
it's
said Bert.
fried.
It's right.
It's fried
Right.
here.
Correct.
But that doesn't change the fact that you have experts that may be the subject, especially in venues where they allow expert depositions, they become the subject of unfavorable orders. That can change things in terms of how a case is perceived, and one needs to have a conversation with clients. might not be a pleasant one, because after all, we as plaintiffs' counsel are the one retaining these guys and gals, but you need to have that type of a dialogue, and vice versa. You see defense experts that get struck. And again, assuming that I know that defense expert Joe Blotz got struck under Daubert in some Kalamazoo, we'll call it, I don't necessarily expect the next day to get a phone call, even if that is the primary expert, and increase the offer to me. It's a process where it's something that's important to know, and it's important when you have a substantive discussion down the line. But yes, I mean, we anticipate that there are going to be fact witnesses, expert witnesses that do things or have things done to them that are not favorable to our position.
And to both of your points, I appreciate when, and even when we have a hiccup in our case that weakens our position, I'll say to them, all right, you got this, but here's why our case is still good. And I appreciate when a plaintiff's counsel goes, yeah, you got your I got my expert stricken, but here's what we have, and it's an honesty to it. I've had plaintiff's counsels like, oh, that doesn't matter, I can still proceed. Like, is the advocacy tone in the discussions you're having just on the phone where no one's listening, you want your plaintiff's counsel to be like, all right, yeah, you got me on that, but to be an advocate on the arguments that are still viable, and we've had them just continue. But
I think everyone's style is different, and you're going to come across all
That's true.
sorts of plaintiffs' counsel on our side. And I think to some degree, people still hold out hope that maybe you can rehab whatever happened with a later witness, or with additional fact discovery, or something like that. That may not mean that was a death knell for your demand or for your case, and you can kind of rehabilitate it as time goes on. I mean, that certainly has happened too. But maintaining a good relationship with defense counsel is always a priority for me. I really tried to strive to do that, because I think it ultimately benefits the client at the end of the day.
yeah,
Not fighting every single battle.
Pick your
battles.
Pick your battles. All right, the next thing we wanted to know is if you guys could candidly tell us what we should stop doing, what we should start doing, or what we do well that really serves to devalue your case. Impart some words of wisdom on either our insurance carriers, our adjusters, our clients, or counsel, what you think we should do, stop doing, or continue doing.
Pick your battles. Pick your battles. That's the biggest thing, I think, because sometimes defense counsel can be so obstinate and fight every single issue, even if it does not really matter at the end of the day, and it just makes people dig in. And it's difficult to overcome that type of relationship from the beginning. So that would be my advice: is pick your battles. Don't fight every single issue. Be reasonable on some of these things, discovery issues and things like that.
Well said. I like the precursor also. Be candid as to that. That's always the when one is in a deposition and one's own client answers a question with, well, if I'm being totally honest, it's like, or being sworn to be totally honest, whatever's coming next is probably going to be confessional.
Right.
So yes, candidly, the things that I see that I don't, I'll put it this way, that I don't particularly understand. I have never understood the tactic of withhold documents, because there's that old adage, I'll grant you that 3 people can keep a secret, but only 2 of them are dead. Once you start deposing people, you will find out about these documents. Ultimately, it's hard. Documents have tails.
Not always.
Not always fair. But I would think that those are probably better arguments for admissibility down the line in terms of a motion in limine, rather than seeking broad-based protective orders that prohibit turning it over. Mm-hmm. First of all, I haven't seen that usually work in a successful way for the defense, because most jurisdictions are going to be fairly liberal in terms of their approach to discovery. Yeah, those are very interesting arguments as to why maybe a jury shouldn't hear about it, but for now, turn it over. I've also never really seen a defense harmed by being liberal in terms of how it turns over discovery. I have seen defense get annihilated as a result of holding documents back, with the court finding that there was no good faith reason to withhold that. Mm-hmm. What the defense does well.
Is that hard to figure that out?
Not at all. If we look at success rate, and again, this is how Oliver and I met. Since we talked about venue and value, and they don't merely share letters in common, I am always surprised when there is an aggressive fight for a motion for summary judgment, but not an aggressive fight for, we'll just say, forum nonconvenience, for example, or especially forum nonconvenience dismissal. Here in Pennsylvania, for some reason, forum nonconvenience dismissal is actually easier to obtain. It's a weighty reason standard, although the Superior Court just came down with a ruling about 10 days ago that slightly recalibrated that, as opposed to the oppressive and vexatious standard that it goes from one Pennsylvania venue to another Pennsylvania venue. I've always thought that in cases where venue is not established by statute, meaning it's not a med mal case or it's not a case where the Commonwealth is a party, that all of the effort and energy that goes into a summary judgment motion, where that burden is just enormous on the defense, why that wasn't put into selecting a venue that the defense would be able to articulate a better and more favorable story than, say, a venue that the plaintiff chose. So that would be my belief. And again, that's one of the reasons why I admired Oliver. I mean, that case was in suit. That auto defect case, I think, was in suit for 3 weeks. Oliver did not hit me with boilerplate preliminary objections or anything like that. It was immediate recognition that Philadelphia is not where this, we'll say,
should be,
non-United States manufacturer wanted to be. It was somewhere else, and it was this massive motion. I think he acquired, this is not hyperbole, 25 affidavits, and you look at this,
Wow.
and I thought to myself,
You did do that, didn't you?
okay, he did, and we as an office looked at that and thought to ourselves, we have to come to some agreement in terms of where venue is going to be, because we are going to lose this. And if we take it up, we are going to get Superior Court case law, hopefully unpublished, that is not going to be favorable to the plaintiff's side. So if I was advising the defense as to where to put the energy in, whether it's a dispositive motion for summary judgment or a fight to move the case elsewhere, it's the latter every single day of the week.
And it kind of goes back to picking battles, like you
Yeah.
were saying.
For me, pretty please stop with the ridiculous economic damages reports. It smells of weakness when I see an economic report that claims something that not even the craziest liberal jury on earth will believe. We recently had one where it was a young lady who had a very serious injury. I won't say any more because maybe somebody listening could piece it together. But if you read plaintiffs' vocational and econ reports, the reports stopped only about 5 years out from the accident in terms of growth. But if you projected that all the way out, by the time she's 40, she's making $650,000 a year. This is a person who spent more than half of her adult life in jail, who has a very serious drug problem, and who has never, ever, ever earned more than $24,000 in a given year. And yet we are to believe that by age 40 she's cranking $650 a year. But why do that?
I don't, without knowing the parties involved, Mr. Brooks. I can tell you, just because we sometimes retain experts does not mean that we necessarily call experts. And to that end, something that I have never understood, I have seen defense counsels, I'm sure people at this table could do this, do a very, very comprehensive job at trial, cross-examining economics experts, vocational experts, life care experts, sticking just with economics. They've got the jury believing that this is just voodoo, okay? And nevertheless, when it comes for the defense case in chief, they put their own witch doctor on the stand, okay? Which does two things. Number one, you validated the science. I don't know which of your carriers tells you to call economists, but also what happens as on cross. The jury tends to get reminded of what the plaintiffs put up on the board. So that always has bewildered me, the defense attorneys who will call an economist as on trial, and what's the last thing that's going to happen? Generally, they call the economist last, and the last thing is the cross-examination of the economist. So going right into closing, what do you have? Reminder of the plaintiff's boardable economic losses, inflated or alleged to be inflated as they may be with Mr. Brooks' example. So that always has confused me in terms of it. I've always thought that it would have been a better strategy to merely invalidate or attempt to invalidate the plaintiff's boardable damage experts.
Well, see, our thing on that, though, is if we don't put up a counter number, then if the jury doesn't believe our cross, then they're left with your number.
Yeah.
So
And we almost never put up a 0.
Yeah, well,
A
true.
report may list a 0, but then it has, but really, and then it has a much more realistic.
And that's, I think, a large part of why I know there's sometimes I don't want to put up an econ for that reason, but I'm like, it's either the jury's going to have to decide between a $4 million econ number or nothing. I have nothing more reasonable to give them.
In terms of evidence as opposed to merely your cross of the plaintiff's expert. I understand that. I would think that in a disputed liability case, maybe you don't want the jury thinking about numbers at all, just in terms of a tactic. And I've seen it done where there really is no pushback at all on the numbers. It's merely, let's talk about negligence, products liability, or of course the scariest thing to plaintiff's attorneys, negligence but no causation in terms of the verdict, rather than getting into a back and forth in terms of the numbers. But yeah, I mean, I get it, and I understand for defense economists for a mediation, perhaps for an arbitration, but putting somebody up there on that, provided you've done a good job demonstrating that economist's numbers are speculative. Certainly the hypothetical you laid out.
We say bullshit.
All right,
Politely.
On that bullshit comment, I'll move on to the next question, which is, in your initial client intake interview, how important is their likability to you? I'll start with you, Tracy.
From my perspective, I don't take that really into consideration in the initial client interview. And I have to be honest, we talked about this before we went live. Some of my most cantankerous clients in the initial client interview ended up being my favorite clients at the end of the day. They ended up being the sweetest people, and they came across so well later on down the line, but they're naturally suspicious when you meet with a lawyer, and as some people tend to be, and they're just angry because of whatever they've gone through, and so I don't really put a lot of weight into it from an initial client interview perspective. I mean, granted, that's happened, and then down the line they are still
Not likable.
cantankerous.
And you have to deal with that.
You have to deal with that, but generally I don't put a lot of weight into it right out of the gate.
Agreed. Again, I think the issue always is not whether I may personally find a client likable or not. It is what eventually is the jury going to do with this particular person. And yeah, there is truth that, look, someone's personality is going to show through, no matter how much you prep them for a deposition or a trial. If they are internally angry or aggrieved, but there is probably a way to channel that to demonstrate that they're feeling aggrieved as a result of this fill in the blank, defective product, inappropriate procedure, et cetera. But as you close in on trial, I mean, we've all been in mediations where a mediator will candidly tell you what they think of your client. Now, that's, there are reasons for that to move people off of numbers, but usually if they're telling you a perception of a client that doesn't square with reality, they're not a very good mediator. Most of the time they're telling you that which you already know. You got a problem with this particular client, just like I'm sure on your side, you've got corporate reps that people are putting up, or a defendant truck driver, et cetera, and you might have that initial interview and you think to yourself, this person's going to get skewered, and this is going to be the face. Now again, when it comes to corporate representatives, there's more discretion in terms of who you pick.
We get to pick them.
Precisely.
You don't get to pick
it used to be, the
Provided
person
there's
most
someone to
knowledgeable. And I've had depositions of people that are not only persons not most knowledgeable, but they don't appear to be knowledgeable about anything. I mean, that again is you have to pick your battles. And both of us, we decide whether we're putting these cases into suit. So I think it's fair to assume that once these cases are going into suit, any characterological deficiencies of these clients we think we can overcome or we think we can explain away. But that ultimately, it's how is a jury going to be viewing these people.
Or keep them hidden. Yeah.
We talked earlier today about not holding stuff back in terms of it. Let's be quite clear. If somebody has got some severe deficiencies that you think are disqualifying, you are obligated not to pursue that. Otherwise, you're just burning through your own checkbook in terms of it. It's our money that's going on the street.
Yeah.
And if it's, look, if this shoe drops, this case is kaput. The person who is really feeling it, in addition to the person catastrophically injured, is the plaintiff's law firm. It's our money on the street for the liability and the damages, et cetera. So it does not behoove us to play around with cases that we think have this, I mean, again, I don't like to talk about trump cards, but if this comes out, goodbye case, it would be tough from just a pure business perspective to engage in litigation.
All right, our last question, is the perception of empathy from defense counsel important or significant from your perspective?
I'll go first, sure. Is it significant? Absolutely, it's significant because empathetic defense counsel at depositions are dangerous. I mean, if somebody is coming in there and breathing fire at your client, I mean, you don't even really need a plaintiff lawyer in a lot of situations because the person's always going to be on guard and the person's always going to be very careful about how they answer the question. It's the people that are either genuinely or have a good stage version of empathy that are much more dangerous from my side. I mean, look, as empathetic and sweet and wonderful as defense counsel are, you have a zealous representation of client standard that you have to meet, and that involves paying our clients as little as possible or as little as you possibly can, because that's what your clients are retaining you for, not because you're sympathetic and nice. These are just tactics in terms of how they come across. And yeah, people that can, act as the can opener to smile and be empathetic, again, genuinely or at least create the perception of, then you have plaintiffs that will follow you down garden paths, et cetera. So yes, it's quite potent and dangerous, and that can be a large part of the prep session. Look, just because Mr. Brooks is smiling and expressing sympathy, which is no doubt genuine, these questions are not designed to elicit testimony that is helpful to the plaintiff's side. It's helpful to the defense side, or it's building a component of the defense. Again, the people that are angry and aggressive, not merely in written form in terms of emotions, which is sometimes more understandable, but actually do that in a deposition, I've never found those individuals to be either terribly capable or terribly effective, because that's not the right, type of personality that will lend itself to a productive deposition. Or a good relationship with plaintiff's counsel. I mean, what's the phone call afterwards going to be if someone went in and screamed at a grieving mother? And I had that happen. It's very, very easy not to take that person seriously or say, look, in light of your conduct, now everything is in writing, and then there's not going to be the opportunity for communication to see if something can be done in a way that is advantageous as picking up the phone and having a dialogue. So look, I get it. I understand that people want to have that tough person persona. And look, I think your case is great, but I'm here to tell you that it's not good. If you then go into the depositions that way as heartless, how is your client advantaged to that? I don't know any plaintiff attorney that thought just because the defense person was a nice guy or nice gal that is demonstrating weakness. I've never seen that. I come from a family of defense lawyers. Bias aside, they're all nice people, and as a result, they're all dangerous in terms of how they take the deposition.
Well, and I think your point is so well taken, and I don't think enough defense counsel do this, especially in deps and mediations, where you want the plaintiff's guard to go down. And when their guard goes down, more information comes out, more real information comes out. If you can get your plaintiff talking, inevitably it helps the defense. And the last thing that the only way that doesn't happen is if you come in with your guns blazing, cross-examining. And I say to all these guys when we go to mediations, it is not an adversarial process. If you start off your opening, you have to talk to the plaintiff, or your one opportunity to talk to the plaintiff directly, to have them get a sense of who you are, and that brings their guard down and maybe gets, like we talked about before we went live, a sense of, they've had their day in court. So I completely agree with you.
Yeah, I absolutely 100% agree. I can say that the most effective deposition takers that I've seen over the course of my career are the defense lawyers who are very personable, they're humble, they're nice to the client, and then the client develops a rapport, which we are over here flipping out about, but they develop a rapport with defense counsel, and they start talking, they start offering information, and then there's 1,000 more questions that come from the information that they offered. Whereas on the other hand, when you have defense counsel who come in and they start bullying the client, there is nothing that angers me more in the course of a litigation than watching a defense counsel bully my client during a deposition. I hate it. It ruins the relationship for the remainder of the litigation when that happens.
Especially for resolution.
Yeah.
You don't have to bully them. They want to talk.
The other thing I would say about that is if you're at the point where you're at a mediation and the client is present and it's a case that is questionable and I have a difficult client that's making it difficult to resolve the case, sometimes the defense approach of being sympathetic and empathetic towards the client in that situation is enough to make the client settle down and be more reasonable because they feel like they've been heard and they feel like they are understood. And whether that means anything or not, it's the perception to the client that they feel like they've been heard. And sometimes that's all they want, really.
Certainly with mediation and the bedside manner that we talk about, that why do physicians that have good bedside manner tend to get sued less, even if the medicine is not necessarily up to par? It is that perception. But also, I think, it sometimes gets overlooked, like going into a mediation, it's sometimes, especially if you have a rapport with opposing counsel, to have a talk with opposing counsel beforehand in terms of presentations. Like, who are you bringing in here today? Are they the type that want to see a plaintiff's presentation, or do they just want to get into separate rooms? More importantly, when we talk about defense presentations at mediations, I think it's worthwhile for the defense side to reach out to us and say, what do you think in terms of it? Because look, everything you think we need to know, we know. If we've been following our cases, we know. And there might be times when an adjuster needs to hear the plaintiff's perspective on the case, just to see if they don't have any experience with the plaintiff's side, can this plaintiff's attorney tell a story? Okay, let's just get the quick narrative. It doesn't always translate well in reverse. You can get somebody who's already feeling defensive on the plaintiff's side. I'm already injured. Why am I hearing about how the experts my attorney hired are no good, or why the defense experts are better? Again, in a mediation format. I mean, that sometimes, again, though, you might have a client that is problematic on the plaintiff side and needs to have their expectations managed, and sometimes, I mean, that can be beneficial, as was just said, in terms of seeing it. Because then when you go back into the private rooms, you have that dialogue. Look, I've been telling you now for months that this is what they're going to be saying. You've now seen it. Pretty persuasive, right? Other times it's, okay, yeah, you have quadriplegia, but, what are you going to do? I don't necessarily, and I've been in mediations where it's basically been that. And then what have you done? You have incentivized a trial, and if you were really gung-ho in having a trial, why are you at the mediation to begin with? So, you understood that.
And on our side, we need to do what we espouse plaintiffs to do, is to separate liability and damages, because I'm not an inherently empathetic person. I'm just not.
No.
I'm really not. I have, over the last couple of years, been trying to build that.
You portray it well.
The easiest way for me to do that is to separate out the liability versus the damages. In an example, if you have a single car severe accident where the person is really injured, patently injured, but that person was going 100 miles an hour on meth and lost control and was injured, it's easy to say, well, you got what you had coming to you, Luckily it was only you and not somebody else as well. But if you can divorce yourself from the liability, how they got there, and only look at how they are, it's much easier for me personally to say, wow, I wouldn't trade positions with you for all the money in the world. So that's just my thoughts on empathy. I did have a tag question for you guys. Well, how do you feel about, particularly in a mediation setting, where defense counsel opens up with a 2 or 3 sentence statement directed to the plaintiff that says, and I'll paraphrase, Trish did this in one of our rather contentious cases, where she said, we're sorry that you were hurt. Everyone understands that you were hurt. There's no getting around the fact that it's a serious injury. and we're not diminishing that impact on you. However, we're here today because we don't think that we are the cause of your injury.
This is in a mediation setting?
Correct.
We talked about earlier today about how I've never found somebody who was nice to be demonstrating weakness in terms of depositions. There's something else I've never really understood. How anybody is ever hurt from telling an injured plaintiff, we'll take a person in a wheelchair, or take somebody with a full body burn, say, look, we are here today in good faith. We hope that we can get it resolved. We are sorry that we are forced to meet under these circumstances. Mr. Mediator, Madam Mediator, I think that's all for now. We'll go into our separate rooms. The ball is not dropped from that perspective, ever. It's not judgment on the case, as you were talking about quite accurately earlier today. All it demonstrates is we are here because we take this seriously. We are obviously here because we take this seriously. And I don't understand how anybody ever gets harmed from that. If you want to use a mediation to deny liability, or to state that to the other side, that we are here because we don't believe that we proximately caused, or we don't believe that we did anything incorrect. Again, that's assumed. Okay, so I don't know why that would need to be necessarily reinforced in terms of a statement, because again, you're going to potentially get the other side more entrenched, for lack of a better word. But also, if that mediation starts to go sideways and down the line a trial judge wants to know what happened, somebody with a gavel wants to know what happened, I would caution against the other side, giving the other side the opportunity of, look, we came there in good faith, and they, basically their first statement was, we deny that anything we did was wrong, and as a result, my client was almost inconsolable. It was a rear-end accident, and they wanted to talk about meth, or they want to talk about all this stuff in the background, and again, you're poisoning the trial judge.
Well,
that
I
way.
think some of it is, and I struggle with this all the time on mediations, and I take each one individually on the approach, because it is the one time I do get to talk to the plaintiff directly, and not in a deposition setting or something like that. And I struggle. Sometimes I want them to know, and I think you don't say it in an adversarial way, but I want them to know that we see their case slightly different than they do. And I know sometimes I have done that effectively, and sometimes I haven't, where the mediator's like, I had to calm them down a bit, and I've tweaked that sense. But I don't know. I see your point. I think sometimes it is worth stating the elephant in the room in a as nice as way as you can. But
we see the case differently, by the way, is fine. Again, that's not a judgment on the case.
Yeah.
Firm will see a case differently in terms of we bring it in, but it's always what is the goal towards? The goal is getting the case resolved. If you start, and again, it's the same thing again on our side. That's why I talk to defense counsel and say, is it worth it with this adjuster having a discussion about liability going into the mediation? Because if it's just, let's talk about your defective property, let's talk about your defective product. If they're not interested in having that discussion, it's like, we're here, we have our money, we've already looked at the case. We have experts just as good as yours, if not better in our opinion. We know. Ultimately, the adjusters and the corporate defendants, one would presume, are going to be less moved by a presentation, but plaintiffs can really be moved by a presentation. We had a case involving a girl who was partially ejected, turned into a quadriplegic. Target defendant was not an automobile manufacturer, I might add. Just said, this is the most boring presentation I've ever heard in my life, and just walked out of the room.
Wow.
The case did not resolve at mediation as a result of that. And again, trial judge heard about that down the line. Why didn't this go through? You told me that you were going to mediation. How come the mediation only lasts 25 minutes, et cetera? I am guarded about giving my opponents something that they can just crack me over the head with. Same thing. What if I go into mediation and say, here's my number and I'm not moving off my number? You may have had that experience happen to you. That doesn't sound like a mediation. Right. That sounds like an ultimatum.
Yes,
okay? Why would you tell your adversary that you're going to a mediation where it starts at the insurance policy upper echelon, and then we'll talk about corporate assets? It's like, did they know that going into that? Why did you do that with them? It'd be the same thing in terms of presenting to somebody, especially if somebody is badly hurt. But yeah, you can certainly let them know that, hey, we see the case differently, but that's different than, you got serious problems in this case. You know it.
You're not going to recover ever.
Right.
And in Tricia's defense, that instance where that was done was a plaintiff who had diminished mental capacity, not due to the accident. That's just how he was. He was also a scumbag. Unmitigated.
I will tell you really feel.
I will say that his plaintiff's counsel did not think he was a scumbag, but
Yeah, unmitigated scumbag.
and I did not share those. I thought he was okay.
He's the only one at a deposition that I can recall ever just going after. And it worked out in that case because not only is he a bad person, he's a liar.
All right. On that note,
Yeah.
why don't we end that?
I can say one thing though. I don't think it ever hurts at a mediation for you to come out and talk to the client and say that you're empathetic, that you understand it's a serious injury, you're not disputing that, and we may have a difference of opinion about the causation of that, but I just want you to know and acknowledge that they have an injury, and I think that would be appreciated by the majority of clients out there.
Absolutely.
I really do.
In terms of that. And the mediator. I think the
And
mediator would
the
approve that as
plaintiff's
well.
lawyer, honestly.
Well, great show. I love the questions, and I love that you guys are so candid. I'm going to wrap up our last segment by just talking about what you guys think is hot now, what is going on with you. I'll turn to you, Tracy. I know you guys are at the forefront of the vaping epidemic. What's going on with that?
Oh, it's crazy.
If somebody's listening that either vapes or has a child that vapes, what should they look for? How do they contact you? If you could speak to that.
Yeah, well, anybody, first of all, to answer your last question, we started a website called endvaping.org. And it is really dedicated not so much to litigation, but as to help fight this crisis in the youth across the nation. And we're going to schools nationally and helping do educational programs as part of a larger public service that we do in terms of distracted driving and trying to help end youth distracted driving and texting and things like that. So we've started that. It's on endvaping.org. There's tons of information on there. But going back to the whole vaping epidemic, obviously it's a huge problem. And if anybody has kids who are in high school, which, your stepson, I have teenagers, 4 boys, 2 of them are in high school, and they will tell you that everyone is doing it. The numbers are 1 in 4 teenagers, but the reality is they're much higher. If you talk to kids in the high school setting, they think it's safe. They completely do not understand what they're doing to themselves. So that is absolutely a big litigation. If you look at the marketing tactics that were done, there's no question that they were marketing to kids. I mean, they'll say they weren't, but there's just no question about it when you look at the actual ads and the launch parties and the things that were done. And now, unfortunately, we have an entire generation of kids who are addicted to nicotine again when they probably never would have picked up an actual cigarette because there was a stigma attached to cigarette smoking now that wasn't there 20 years ago. So, we've reached an all-time low in tobacco use, and now we've gone back 20 to 30 years of progress, unfortunately, because of this vaping and the aggressive marketing that was done. So
It's scary.
So it's really scary if you have kids.
And it's associated with man buns, which is a real problem.
I don't know about that. I think it's a little more widespread, but it is a significant problem, and it's the tip of the iceberg. We don't even know what the long-term effects are going to be. That's the problem. We're seeing short-term effects, and we don't even know down the line where the long-term effects will be.
Yeah, that's it brings to mind the tobacco wars, as they're called, in the 1990s, and these records were uncovered that showed that tobacco companies were giving little kids dip tobacco, cigarettes, et cetera, so especially with the social media that were pushing these vaping devices, and and for a while it was, of course, the lithium batteries that were exploding. So, I mean, I think we're slowly moving in a direction where hopefully people don't do this anymore, but yeah, it has come roaring back with the e-cigs. So best of luck to you and your firm with that.
You brought up the tobacco litigation, and the early discovery indicates that the manufacturers of Juul, which is the market share, they use the tobacco repository of documents in marketing their product out of the gate.
That's
because
crazy.
it was successful, and they know if they get teenagers hooked that they have customers for life, So it's unfortunate. It really is.
And with with my firm, we have 2, sticking with sort of the topic of national campaigns in terms of litigation. We're heavily involved with the Boy Scout litigation. You can look at Abused in Scouting. You may have seen some television ads, or maybe your listeners have. We're handling that, as well as talcum powder. That obviously, it seems like just about every week there's a development in that regard. Most recently with talc being pulled from the shelves. Again, a simple Google search will indicate why those cases are, to use your expression, hot right now, and will likely continue to be. Myself, it remains automotive defect. It keeps me very busy. It seems like with every development there is in a car as we proceed towards safety, there are problems, oftentimes as a result of inadequate testing or insufficient testing or disregarded testing. But that continues to occupy at least the overwhelming majority of my time, whether it's a bad seatbelt, bad tire, bad airbag, or as Mr. Brooks might say, a otherwise adequate product that had a unexpected result under a very, very, very specific set of circumstances.
The hell of a crash defense.
Yes, ma'am. The
All
hell of a
right,
wreck. Yes.
Well, guys,
Right.
I really appreciate it. Thanks for joining
Thank
us.
you.
Very, very informative. I hope you come back. And thanks for joining us, everybody. Until the next time on The Defense Never Rests. Thanks.
Great. Thanks.
Do we lose sound? Has it been off for a while, or just okay,
no,
good.
it just went down, yeah, no.
That ticks me off to no end. I hate it.
I've
When the audio cuts out, me too. It's outrageous.